2, 1, recording now.
Good morning. It is 10:02 a.m. and this meeting of the Agricultural Labor Relations Board is now called to order. First, we'll go through the roll. Board Member Broad.
Present.
Board Member Hall.
Present.
Thank you. Board Member Lightstone.
Present.
Thank you. We have a quorum on a full board here today. I'll note we had hoped to provide interpretation for our presentation later today. Unfortunately, there were some technical issues. If for some reason that changes between now and the start of the presentation, we will let you know and advise those observing the meeting to turn on the interpretation button in the Zoom. But at this point, we are not activating it. And apologies for that. I will go on to our next agenda item, which is approval of the most recent meeting minutes. May I have a motion to approve the meeting minutes from May 27th, 2026?
So moved.
Thank you, Member Broad. May I have a second?
Second.
Thank you, Member Lightstone. All those in favor to approve the May 27th meeting minutes, please say aye.
Aye.
Aye. Thank you. The minutes have been approved. There is no chair's report today. We will go next to our executive officer's report on elections, unfair labor practice complaints, and hearings with our executive secretary, Santiago Avila Gomez.
Thank you, and good morning, Chair Hasid, members of the board. It'll be a short report today that can be found on our website under the meetings tab. So for commencing with ULP's unfair labor practices, there have been no complaints since our last board meeting. With respect to board activity, there was a board administrative order issued in Olive Hill Greenhouses, Inc. on June 1st. The citation is ALRB Admin Order number 2026-06. There, the board ordered the remand for a second time to the mediator's report and ordered dismiss the petitions for review that had been filed without prejudice. The underlying case number is 2024 MMC-002. And that takes me to pending matters. There are 3 pending matters before the board. First, CYMA Orchids Corporation involving the board's decision in 51 ALRB number 2. The regional director submitted a statement in support of a proposed bilateral formal settlement agreement on May 29th. The underlying case number is 2023-CE016-SAL. The next is Trifanuki Farms that involves the board's decision in 52 ALRB number 1. There was a revised make-whole specification filed on June 1st, 2026. There's an answer, if any, due on or before June 16th, 2026. And that involves case numbers 2013 CE008 VIS and 2013 CE014-VIS. And finally, Wonderful Nurseries LLC involves a majority support petition objections hearing 2024 RM002. There, the IHE, the independent hearing examiner, issued his recommendation to the board to close the record in the matter. That was issued on June 8th. That concludes my report. Happy to answer any questions.
Thank you, Santiago. I don't have any questions. Do any of my colleagues? Okay, great. We do not have a litigation report today. We will next go to our general counsel's report with our general counsel, Julie Montgomery. Santiago, Julie indicated she would be appearing via Zoom. So I'm not able to see her on our screen.
Okay, I'm adding her as a panelist.
Good morning, everyone. Can you hear me?
Yes. Good morning.
Hello. So just a quick report here to announce a couple of settlements that we've achieved since I last reported at a board meeting. and just a few outreach highlights from the General Counsel program. So first is to settlements. They're both out of our Region 1. And the first involves Taylor Farms, which was a charge filed in 2025, alleging that Taylor Farms and Valley Pride retaliated against Monterey County lettuce harvester when she was suspended and terminated from her employment, allegedly because she engaged in protected concerted activity by complaining about the mistreatment she and her coworkers experienced from their foreman. The parties settled with the ALRB, and respondents agreed to pay the charging party $3,668, which included about $2,168 in back pay, and then the rest of it as payment in lieu of reinstatement. And we also achieved the standard noticing remedies as well. The second case involves J&G Berry Farms out of Santa Maria. And that involves a strawberry harvester who filed a unfair labor practice charge alleging that J&G Berry Farms agents interrogated workers at their homes about their participation in a wage and hour lawsuit. And the General Counsel's office and J&G Berry reached a settlement agreement for all standard noticing remedies, and no back pay was owed to workers, as there were no allegations of anybody losing out on their work or wages. So those are two settlements. And then turning to outreach, our staff has been busy as usual. Of course, there's, the harvest is going on in a lot of areas. And so there's a lot of things happening, but I'm just going to give you a few short highlights in the interest of time. Our staff has been hosting office hours regularly in Greenfield, which is in Monterey County, at the Family Resource Center, which is through the Greenfield Union School District. So we have staff who go there for office hours and provide information and services so that we can increase access to members of that community, because of course it's somewhat far to get to an ALRB office from there. And our staff has also participated in a one-stop clinic. This was through our rural RSEP program, Rural Strategic Engagement Program. And this was hosted by TODEC in Coachella, and that was back in May. And they did outreach at the Oaxacan Community Shed at the Center for Farm Worker Families in Watsonville. They also tabled and distributed materials, did outreach at a mobile clinic hosted by the San Francisco Mexican Consulate in the city of Eureka in Humboldt County. So they got all the way up to the northern end of the state to do outreach to farm workers in that area. And they provided an in-person worker advocate training hosted by CBDIO with interpretation in Mixteco in Lindsay in Tulare County. They provided an in-person training to a cohort of the Residential Leadership Academy hosted by the Monterey Bay Central Labor Council in Salinas. They provided 2 different trainings to staff and members of the organization ALAS in Half Moon Bay, and that's in San Mateo County. And they were interviewed on KBBF Radio Líderes del Futuro program in Sonoma County. And in fact, they are going to do another interview later this week on the same program. It's a monthly show that radio station hosts. They have done office hours with organization ICUC, which is Inland Congregations United for Change, in Thermal, which is in Riverside County. And they also distributed information at a farm worker resource fair hosted by MyCop in Santa Maria. And I think those are all of my highlights there. Like I said, there's a lot more than that. This is just a few highlights. And so that concludes my report, unless there's any questions.
I don't have any questions. Always appreciate the work of our team, and it's really exciting to hear about events in places like Eureka, where I know we typically haven't been very often. So thank you to the team for making the trek up there. And also to hear that we have a consistent relationship with ALAS in San Mateo County. I know that was something that was new for us with the tragic Half Moon Bay shooting. And it's good to hear that several years later, we've started to really build some kind of annual events with them and regular training. So appreciate that. Any other comments or questions from my colleagues? Okay, thank you, Julie. Appreciate it.
Thank you.
We do not have a legislative report. Our next agenda item, I'm very excited about. It is with Ruben Lugo, who is the owner and lead consultant for Impact Ag Labor LLC. This is an informational panel on farm worker traffic safety. This is I've heard versions of this presentation from Ruben before and found it very informative, very sobering, and really critical information. So I'm really excited, Ruben, that you are spreading the information here with the board, and hopefully we can share it with our stakeholders and hopefully spread more awareness so we can increase farm worker safety. So with that, I will hand it over to you, Ruben. Thank you.
Thank you, Victoria, and the board for the invitation. And let me see if I can get my screen up.
Let me briefly interject. It appears that we do have an interpreter joining. So while Mr. Lugo gets his presentation set up, I will admit the interpreter and we'll start the interpretation.
Okay, can you relay that information in Spanish as well, Santiago, and turn on the interpretation button for those that wish to listen in Spanish?
Yes. Buenos días y gracias por acompañarnos hoy para nuestros audiencia que habla español. Parece que sí vamos a tener intérprete. Estoy trabajando para unir ese intérprete a nuestra junta. En cuanto lo hagamos, vamos a aprender esa herramienta de Zoom. Tiene que estar usando la aplicación de Zoom por su computadora para usar la herramienta que le da acceso a interpretación. Va a haber un glóbulo hacia abajo de su pantalla. Debe de hacerle clic allí para escoger el idioma que quiera escoger para escuchar. Aunque vaya a escuchar en inglés, por favor elija el inglés cuando vea el glóbulo. En este momento todavía no hemos empezado esa herramienta. Deme unos minutitos aquí para encontrar el intérprete. Gracias. Just give me a minute to get the interpreter joined and see where they're at. All right, our interpreter will be joining us here shortly, and I now need to have the interpretation turned on. Give me a moment. Rebecca, if you're able to hear me, I am promoting you to panelist in order to give you access to the interpretation tool. Please, when you see the message on screen to promote, please accept. Excellent, thank you. All right, now just give me a moment to add you here. Okay, the interpretation tool is now turned on. I'll go ahead and relay that message in Spanish. Para nuestra audiencia que está unida a nuestra junta, la herramienta para intérprete está activa. Por favor, vaya hacia abajo de su pantalla en Zoom, haga clic en el glóbulo y escoja español si quiere escuchar en español y si no, inglés. Aunque no vaya a usar la herramienta para escuchar en español, por favor, elija inglés. Gracias. Yes,
Just let me know when I can start.
correct. You'll be
Yes.
interpreting simultaneously in Spanish into the Spanish channel. You should have the interpretation tool, yeah, right on your screen.
Okay, so can I start now?
Then you'll switch right back to English.
Um,
Yes, thank you.
Okay, Santiago, is Ruben able to start?
Hold on just a second. I'm in the Spanish channel. Apologies. And say that again, Chair Hasid.
Is Ruben able to start?
I believe so. I've relayed the information to folks, so
Okay.
yes.
All right, great. Thank you. Okay, Ruben, take it away.
All right. Thank you, Victoria. I'm going to go ahead and start. We're going to be talking about farm worker transportation safety. And I'm taking this "Why Are Workers Still Dying on the Road" from the CalMatters article that came out after the Lions Farm accident, which is something that everyone should be thinking about. Why are our farm workers still dying on the road? Just a little bit about myself. I started my career with the government working for EDD as an outreach worker for 4 years. And then I was hired by DOL as an investigator in Fresno. I worked there at 16 years and conducted investigations throughout the valley, up by Sacramento, and in other areas as well. And then I got promoted to the Regional Ag Enforcement Coordinator position, where I was responsible for the ag enforcement for the West Coast, would be Oregon, Washington, California, Idaho, Nevada, Arizona, California, Hawaii, and Alaska, and managed those ag investigations in those areas, and also all the outreach that the region conducted for those 14 years. And retired after 30 years, and didn't want to stay out of the out of the area, so I decided to open a compliance consulting company, and felt that I could have an impact working with growers and FLCs, but not with a badge, not with a ticket book, and so to see if they would be more receptive to the message of compliance. And as I mentioned at the last UC Davis, most of my customers are those folks that want to be in compliance, and those that don't will probably never call me. So worker safety equals safe transportation practices. And I'm going to go over some of the regulations out there, but also my observations of what I've seen in the last 36, 38 years that I've been involved with farm workers. So this chart came out of the CalMatters article, and you can see that the majority of farm worker deaths are related to agricultural deaths are related to some kind of transportation accident. You can see California versus the national. California has much greater numbers, and this also includes not just commute workers going from home to work. It also includes any accidents on farm machinery, and I'm going to talk a little bit about that portion of it as well. So the way I see transportation, it's off the farm, meaning that you're going to go on public roads, and then you have on the farm transportation, and you can see this makeshift transport with the yellow. That was on farm. That occurred in the Santa Maria area, in the wine grapes industry, and they would transport the workers from their cars up into the fields, and there were steep hills where they would transport these workers. You can see that the tractor pulled that, and you can see the toilets were attached to that. So if those toilets overturned, that'd probably bring down the transporter, the unit that was holding the workers as well. So very dangerous situation. I referred that to OSHA back then when our office from LA found that. So I'm going to talk a little bit more about that. This is another example of on the farm. You can see that John Deere, the green John Deere with the hot iron mesh. The irrigators would stand into those carriages and be transported to the fields they were going to irrigate. Well, in this particular case, this tractor went on a public road. It was still kind of dark, and uh, another car hit them and killed both of the irrigators on both sides that were standing in these carriages. So this was a makeshift. This is totally illegal. And Waging Hour had jurisdiction on this because it was being used to transport workers. So DOL has a farm machinery exemption, but at the point in time, the farm machinery is used for transportation purposes only, then DOL has jurisdiction to cite those unsafe practices. I believe OSHA still has the same capacity to do the same thing. Here's another example right here. You can see the workers in those bins being transported. So this is already at the end of the day. Workers are going to go home. So that's being used to transport. You can see that that's an unsafe situation. Anyone could fall off those sides and be ran over by that tractor or that trailer. So at the point where it becomes transportation, that's when they can be cited. And that was actually taken out of a social media post that one of the workers put on there. So I used to get a lot of my leads off of social media. So here are the government agencies that have some part in regulating or processing any type of authorization of transport. So of course we have the DOL wage and hour, and it looks at through the MISPA or H2A regulations has jurisdiction over transportation. We have OSHA that tends to look at on the farm, but I believe they are now looking and investigating accidents that are occurring. We have the California Highway Patrol that does regulate farm labor vehicles, but that would be 9 or more passengers. And I'm going to talk a little bit about what happened once that law passed years ago. And we have the DOT. They usually only get involved if there's a big accident involving a commercial van or a bus. But they don't typically get involved with, small vans or SUVs that might be transporting workers. And then the California Motor Vehicles does provide the authorization and the licenses to operate farm labor vehicles. So the California Highway Patrol, as you know, when there was that big accident in Five Points, passed a regulation, Section 322, that required those farm labor vehicles that had 9 or more to go in under a safety inspection, and also ensure that all these vans had seat belts. Back when I started with DOL, even when I was a child and worked in the fields, the vans had wooden benches, and they would crowd 14, 15, 16, up to 20 workers on these vans that had wooden benches, and very unsafe. And it took that tragedy of I think 13 or 14 workers dying for a law to be written to require that. So when this law passed, there was nothing but huge vans that would operate. And after about a year or two, there was I think up to 1,600 vans that got registered in California. That went down way down to, I don't know, about 500. And a lot of the raiteros, the ones that use these vans, opted to buy minivans because the minivans would exempt them from the 9 or more passenger requirement for CHP jurisdiction. So they ended up buying minivans, and I'll have a chart later on discussing how they rigged it so they would be profitable and not be scrutinized by the CHP. So the reality is, right now, there's a scarcity of workers. We don't, most of the IRCA farm workers are in their, 50s, 60s now. Not a bunch of young folks going into agricultural work. So right now, there's two options. There's more availability of transporting workers to long distances, and there's workers that will commute an hour and a half. When I was at DOL, and even now in my consulting business, I see workers being transported from Modesto, Lodi, all the way to Sonoma County. And if you know those roads, those are busy roads and one lane, two-lane type roads. And that's like a 3-hour drive each way. And a lot of times the time they're driving is in the dark time when there's no light, and which makes it more prone to accidents. And even last year, there was an accident that occurred. It seems like every single year there is an accident that's occurring from workers being transported from that Stockton, Modesto, Lodi area into the wine country, because they pay a lot more over there. And, the reiteros know that it's profitable and they can charge a higher rate for their transportation fee if they secure jobs for these workers at a higher hourly rate. Of course, we have the H-2A, and the H-2A is very regulated. They can't even put a petition for workers up until they're authorized to transport. They have the correct amount of insurance. Their vehicles have been inspected. So all the H-2A transportation is falls under the CHP jurisdiction and the DOL jurisdiction, and a lot of scrutiny, and even the DLSC, Labor Commissioner, their licensing part also has requirements for the FLCs to start identifying their drivers now, and they're asking for driving reports to see if they have a clean driving record before they will authorize an FLC to have them work for their company. So the H-2A, there might be an accident here and there, but I'm seeing more of those being a true accident, not driver error or negligence on part of the driver. However, there was an accident from a Mexican transportation company that went through California on the way to Oregon and had an accident in Redding. Several fatalities. The driver ran away. I believe OSHA may have investigated that along with DOL. And the grower that hired this company did a very bad job of screening out this transportation company. They didn't have the correct type of buses to transport. Their buses they were using were the kinds that will take people from the parking lot to the airport. They weren't really intended to be used for long distance transport. Nowhere to put luggage. Luggage was with the workers. That I'm sure the luggage caused some damage to some of the injuries to some of the workers. They were flying in the air. But that would be the only scenario. I'm trying my best to educate the H2 employers to really scrutinize, make sure that the transporters they use from Mexico are registered in the U.S. and approved by the DOT to transport in the U.S. So MISPA also, has
Ruben,
transportation.
Ruben,
Uh-huh.
sorry, just a quick question. I do recall that incident that you just mentioned about the transport through California, and the Mexican consulate reached out to us
Correct.
as well, just to see if we could help them locate people. But do you recall if that company, any citations were issued to that company, or if they're allowed to continue in the H-2A program? The company that hired?
Yeah, that transportation company, I don't think no one's using them anymore. So they got blacklisted. But the grower actually contracted with a third party, their agent, to to bring those workers in. So they paid a third party, a legitimate third party, but that third party is the one that dropped the ball. And the DOL did conduct an investigation. I'm not sure if they finalized that investigation. It might still be ongoing now. But I know there was a lot of attorneys involved and it was going back and forth as to who was responsible and if the workers were considered to be employees at that time. But it seemed like the grower did cooperate and was definitely taking care of the injured workers and making sure their medical needs were being taken care of. But as far as holding that third party responsible for hiring not a legitimate transporter, I'm not sure what resulted from that yet.
Got it. Okay, thank you. Sorry for the interruption.
No worries. And you guys can interject whenever you want.
Okay, well, in that case, I'd like to ask a question now, but while you're still on this. So Ruben, I was involved in writing that statute after the previous accident in the Central Valley, because I represented, at that time, I represented the Teamsters.
Okay.
And the Amalgamated Transit Union. And so one of the reasons that it was 9 passengers or more was because that's the where it's considered commercial transportation of passengers and where the seatbelt requirement ended. So in other words, passenger vehicles like minivans have seatbelts. In fact, good seatbelts and shoulder harnesses. But you said that there are Raiteros that are removing the seatbelts or modifying the seatbelts in minivans to try to put more people into it. Am I correct? Is that what you?
There's some of that, and there's also the removal of seats on the bigger vans so that it appears that it only has a capacity for 8. But when you remove that seat, you have that open space, and that's where you can find workers hiding behind that last bench. And I think the CHP has several pictures of how workers kind of hide back there. The CHP is limited to pulling vehicles over on public roads. So sometimes they might miss the fact that there's workers there. I know the DOL used to work in conjunction with them, and DOL would check the vehicles out in the fields, and we would count the lunch pails that were in the van, or we'd wait till they took lunch. No hiding when lunch comes. They're all going to go to the van to get their lunch, right? So we would just count how many people went to the vans, and that's how we got a head count, because of course the Raitero would always say, oh, I just brought my wife and my 3 kids. And there's only 4 of us. But we knew there was a lot more people. So we'd always, one of the best practices that was established was to wait for breaks and lunches, because the workers would go back and get their food and their drinks to eat. And we would just count how many of them walked in. Then we would confront the Raitero and said, I thought you said there was 4. I counted 9. I counted 8. I counted 10 workers. And that's when they would fess up to being in violation. And that's when we use that evidence to cite them. But yes, there's all kinds of schemes that Raiteros use to pack as many people as possible. I've had situations where there was an investigation done and someone may have died, and the Raitero next day had another body to replace that one person that passed away from the accident. The van was still able to operate it, and they continued using it. But there's very little concern for the safety of the workers with many of the raiteros. It's for them, it's a business. For them, it's lucrative, and I might as well just go to that chart right now. Oh, there it is. So a raitero with 3 minivans, that's 77 passengers each, plus a driver. That's 21 passengers. $10 a day is kind of low right nowadays, as that's gone up. But let's say 21 times 10, that's $210 a day. They work 6 days a day. That's 1260 a week. In a month, they've have charged 5,000. In 8 months, they would have had $40,000. So this becomes quite lucrative for them, and this is on top of what the FLC is paying the raiteros, because a lot of the FLCs are attracted to use the services of raiteros because it's easy for them to put together large groups of workers, because a grower might give them a 1 or 2 day notice that they need 100 workers to pick cherries in Modesto. Well, if that FLC doesn't have that many workers on his roster, first thing they're gonna do is call their raitero contacts, and then they all have maybe 20, 30, 40 workers that are loyal to them that they're transporting on a daily basis. And then the raitero and the FLC will negotiate a daily rate. And then on top of that's the front end, the back end, the back door, they're charging this money. So the raiteros end up making money from their daily pay, and usually a lot higher depending on how many workers they can bring, and they negotiate based on that. And then you have this back end that they're charging money. And I know DOL even had a case where a raitero was exchanging sexual favors for a passenger in lieu of paying for the ride. So lots of things happen. The raiteros also sometimes force the workers to buy food from them that their wives may have prepared, and drinks, beer, soda. And sometimes the raiteros even own housing. And so the raitero is charging for the housing, charging for the rides, and has
Charging for the alcohol.
alcohol. Yes. And the thing is, they control their paycheck. And
I mean, it's illegal to transport alcohol, period,
correct,
in that fashion already.
correct. And when I was with you, I remember a wife calling the office. I got the call, and she was saying that she got tired of her husband coming home smelling like beer, because the raitero would always go to the liquor stores, the corner stores out in the fields, and workers would have to buy, the raitero a 12-pack of beer and stuff like that, and along with paying them a fee. And yeah, that's common. And the office in San Jose and Monterey, their case, the CHP had pulled over the van driver, and his breath smelled like alcohol. So he got a DUI. So he was transporting the workers under the influence. So that case happened, I think about 4 years ago in that Greenfield area. So that's common, very dangerous. The vans have really messy titles. That van on that particular case was sold twice before it was used to transport workers, and the title was never changed to the current owner. So I remember we had to do a lot of digging to figure out who that van actually belonged to. So I mean, some of these investigations take a lot of fact finding, a lot of digging to really get to the truth on this. But nevertheless, lots of agricultural workers depend on them for transportation. They either don't have vehicles themselves, or the cost of gas right now is extremely high. So for one worker to transport themselves, it's makes more sense for them to get a ride from a raitero than for them to take their own vehicle. Um, what I've seen in the past is the growers and FLCs that have more year-round work, usually their crews have their own vehicles, because you can see when you drive by the fields that there's a lot of passenger cars. And they work enough months out of the year to be able to afford a home and a car, a vehicle. And then some crews, you'll see a lot of different vans and a few passengers vehicles. But if you see vans in a field, you can almost bet that there's a raitero type of arrangement involved, unless it's a big family, and there are exemptions for big families, but has to be immediate family, has to be um, husband, wife, their children, their parents, brother, sister. That is it. That's the exemption ends there. And of course, we would always, when we interview the raiteros, they would always claim that everyone was related in the van, and no one looked like each other. And so we would have to like dig a little bit deeper and find out that, they were friends or compadres or stuff like that. So here are the people that transport agricultural workers. As you can see, I have raiteros work with the growers. They work directly with the FLCs. And honestly, I kind of view the raiteros as an independent contractor. They have no loyalty to the FLC. They can remove their workers just with a disagreement. If the raitero has a disagreement with the FLC, they'll yank their crew, or if they get a better offer from another FLC, they'll pay them a little bit more. They'll pull the crew out and take them to where the raitero could make more money. And the workers are loyal to the raiteros and will follow that raitero. And of course, they're maximizing profits. But again, to me, I see them as brokers. I mean, I used to call them a secondary or lower tier FLCs, because they really do meet the definition of a foreign labor contract. They're recruiting, they're soliciting, they're transporting, furnishing workers for a fee, and they're negotiating that. Now, DLSC hasn't caught on to that part, but I honestly think that they would truly fall under a definition of a foreign labor contract, because they're doing those activities and they're doing it for a fee. They're not employing or hiring, but they're promising them employment based on their negotiation with their FLC.
I'm sorry can I just ask another follow-up question?
Uh-huh.
Are the raiteros, I mean, they would be subject to the requirement that they get a business license maybe, or that they get PUC authority even for fewer people? I'm not sure about that.
Well,
Are they in any way regulated in terms of the establishment of their business or tract or anything if they're under 9 passengers?
Well, under the state law, there's, they fall under that loophole, and, under DOL, as they transport one worker, they're covered, and DOL can cite them. They have to be registered as FLCs. They have to have $100,000 per seat insurance coverage, and that's one of the ones they can't miss. There are a handful of legit raiteros that have met all these requirements, and they're actually legal raiteros. They're following the rules. It's just a handful, but
Yeah.
most of them are underground economy type of operators. They don't report their cash. Everything's cash. They try to make themselves appear like a carpool when they're not a carpool. They're actually a business. And sometimes they even use passenger cars to even throw the investigators off, so they're not caught. So we've seen some that have 3 big, large sedans or they'll do a combination of SUVs and sedans. And with Department of Labor, if you're a crew leader, a supervisor, and you're transporting, you're automatically on the hook. If you're transporting, you're on the hook, and it's if like the FLC was transporting workers. So the growers, I was going to cover this too, but social media shows a lot of indication of transportation. I mean, pictures workers take of themselves in the field, you can see vans everywhere. And I showed this at the last a couple of weeks ago at the UC Davis. This is a Facebook posting of a raitera soliciting workers. This is in Bakersfield. Carrot workers looking that they have room for 5 more workers that are responsible, reliable, and have a lot of enthusiasm, in English, ganas, to work. And they're already telling them where they're going to meet, right? So, of course, I'm the one that hit the like button on this because I had a meeting with that FLC right away because they named the FLC on this post. So I had a meeting with that FLC that next day, and I said, "Hey, your folks are transport. This is obvious transportation right here." And I used it. He allowed me to train all his crew leaders on this, and I showed them this. I said, "You can't be doing this. You can't be transporting illegally workers. If you're going to transport, you have to do it legally." So it's definitely happening. These were the major violations that DOL Wage and Hour used to find. The vehicle was unsafe, unlicensed driver, uninsured or underinsured, FLC not authorized, or like they don't not authorized to transport, unauthorized driving, because there's transportation authorization, there's driving authorization, 2 separate things. No medical certificate. They're charging for fees, and actually you can charge for fees, but only up to the cost of a transportation, and only when all the conditions and all the requirements have been met. Now, growers can be liable for this, and the regulations hold them responsible to take reasonable steps to ensure that the FLC is properly registered to perform activity they are performing. So how would they check? Well, the card itself tells you if they're transportation authorized, and the person driving would have to have a blue card that says driving authorized and with a medical certificate. And if it was a 9-passenger, then they would have a driver's license that endorses them to drive a farm labor vehicle. And they would have to take a special class from the CHP requires them to take to transport farm workers. So the CHP law definitely works. To my recollection, there was only 1 accident in my years working with the CHP that I can recall. But for the most part, like 99% of their folks that are registered with them don't have these types of accidents, and do not put their folks in danger. And the drivers aren't making driving errors and causing accidents because they've been vetted properly, they've been trained properly, and they understand the importance of following and obeying all traffic laws. Here we have the Lions Farm. This was a grower whose supervisor used a raitero, arranged that. Now, this wasn't the driver's fault, the raitero driver's fault. The truck hit it. Nevertheless, it did disclose that this transportation was occurring and that there was no insurance, and there were other violations attached to this. And I think you guys probably read the article that came out. Cal Matters definitely reported on this. These are all the folks that died, and this particular case really hits home because I saw this live video on social media the morning that this occurred. I saw it. There was a person out there doing Facebook Live and would walk and show pictures of the folks inside of the van that had already passed away, and the one that was alive asking for help, crying for help. It was heartbreaking to see that. And a lot of these passengers did not have their seatbelts on and could have been saved had they had their seatbelts, which is another topic I think that we really need to push in the farm worker industry. And then also with employers, I'm constantly, counseling them to advise the workers on their way out. It takes you 1 second to remind them to put their seatbelts on their way, on their drive home. That would definitely save a life. Here's the press release that went out on this case. There was, almost $90,000 in civil money penalties, $40,000 in, back wages. And this is directly with a grower. All the other ones had always been a farm labor contractor, but this was a grower initiated transfer that was directly responsible. This one, Valley Garlic, which is also heartbreaking. I mean, they're all heartbreaking, but a 16-year-old young lady, Corina Palacios, passed away on her first day of work. She went to work to be able to buy clothes for high school. The driver fell asleep driving from Hollister to somewhere in Merced County, fell asleep, and a lot of folks passed away, including her. And they interviewed her mom, and her mom said she didn't think it would be unsafe because she thought this is a farm labor contractor, it's a regulated business. The driver probably has a license, they probably have insurance, they probably know how to transport workers, but that didn't fall because these are the minivans that fall under the 9 passengers that are not. And the FLC Extreme Ag had 3 minivans transporting at the same time to the same Valley Garlic grower. And this driver was probably getting 2-3 hours of sleep, 4 hours of sleep every night, just based on their work schedule and where he had to pick up the worker and the distance that he had to drive. This was a press release on that one. Here's another one. This is Healthy Harvest and the Fisher Ranch out of Blythe. These workers were transported from Calexico all the way to Blythe. That's a long drive. That tire was a retread, and my understanding, the FLC declined to buy a new tire for that van. So the driver himself, out of his pocket, bought a retread tire. Retreads, are very, very good tires. So, how hot it gets in that area. The tire exploded, and that van turned over, went into the field. There was a bus caravanning behind this van. A young man died out there. The story, and the mom was sitting in the bus watching her son being pulled out of that van when in this accident. So here's a press release on that one. So from these cases, I think something that DOL tried was to make it, the grower was responsible. Fisher Ranch got responsible. Valley Garlic was responsible because, pretty much the growers, for the most part, don't care or turn a blind eye to that. They just say, I hired a contractor to bring workers to work. How they bring it is none of my concern. But if you notice, those 2 accidents were 2 or 3 hour transportation distances. So that a grower would have to realize that your average farm worker is not going to drive 2 or 3 hours, that they're going to rely on transportation to get to work. And it seems like that, and I think DOL used some of that to kind of sway the judge and making a decision that held the grower responsible, along with the FLC. So the grower was mandated by the judge to use registered FLCs who were authorized to transport, and they had to have drivers that were authorized to drive. They had to reimburse, this is really important right here. They had to reimburse the FLCs for transportation cost. And at first, the 5 FLCs that worked for Valley Garlic, none of them thought it would be possible. But if you talk to them after a year or two, they were saying this works. If the grower pays us money to pay for the cost of transporting workers at no cost, then we'd be happy to transport. The growers don't want to pay for that cost. And lastly, the grower was required to monitor the compliance of the FLCs, which is something else that's important. And that's another reason why I opened my consulting business, because there's very little of this monitoring FLC compliance after a major investigation. And there was a need there. DOL could never find anyone to do that for them.
I think my colleague Ralph has a question.
Yeah, hi, thank you. Thank you. I just have as you're talking about if the grower's contract with the FLC requires payment for transportation, is there a standard written contract that growers that are doing that with FLCs that are providing transportation, is there a sort of standard contract language that requires the payment for transportation?
Well, on the Valley Garlic case, and both of them, it was a consent judgment that required them to pay it. It wasn't even part of the grower contract.
Right.
And if you read most grower contracts, they distance themselves from the transportation. So they have language in there that will say, we're not going to be responsible for how your workers get here and blah, blah, blah. So that part wasn't in the contract. They were following the orders of a federal judge that required them to reimburse the FLC. And that's the only reason they did it.
Right. So so there isn't a model contract we're aware of that does that DLSE could look to work with the farm labor contractors.
And honestly, most of the growers will just go on to the next FLC because it costs money to transport, right? So that's going to add maybe $3,000 or $4,000, $5,000 a month to get this service done. It depends on how many buses they have. They have to pay for the bus drivers' wages, gas, the bus, insurance. It's going to cost money. And the growers honestly don't want to pay for that. I'm not sure that they, I don't know how their revenue works. I don't know if the retailer's paying or the packer's paying them enough to pay their FLCs enough money. But I think that looking at this, I think for this to truly work, the retailer has to pay the grower enough so they can pay the FLC enough to get the safe transportation done, especially if they're going to be transporting from long distances. Now, I know Costco on one of the DOL cases was concerned about the transportation and got their attention, and DOL got their attention on it. I just don't know if Costco is nudging their growers enough to, and even paying them enough to make sure that the FLCs that they're using, if they're transporting, are doing it correctly. The H2A ones, I can assure you, they're doing it correctly. But the other ones, and H2A only represents, I don't know what, 5-10% of the entire state of California farm worker workforce. So there's that huge percent that does it, and there's certain crops that are more profitable than others, and there's some crops that are not profitable that I don't know if the margins are there for them to do that. So and I don't know if some kind of subsidies are required to make sure this get done. Now, there was a CalVans program that kind of surfaced to kind of help alleviate this, but the workers paid money for their part of the carpooling arrangement. But I believe that, you know, Calvans may be hurting for funding right now. So I'm not sure that that is available on a large scale basis. But I thought it was a good idea. They had good insurance. They vetted their drivers. And, you know, they made sure they had clean driving records, and they had they met the health requirements to transport workers, and they had the training to transport workers. But I don't know if that's available, but I just kind of putting this out there because this is a problem that I think we all need to put our heads together and kind of figure out what's the best approach to make sure that we're not losing more farm workers in, you know, unnecessary accidents. The seatbelt alone probably would have saved most of those fatalities. There's some that, of course, would not be able to save, but a lot of them could have been saved and would have resulted in injuries, but not in deaths. And this is an area, I think, where all the state agencies really need to focus their outreaches to include talking points on seatbelt usage. I think this is key. This alone will definitely drop the number of fatalities. And even the workers that are driving themselves to work, I think, would benefit from this. And, you know, look forward to working with anyone on this. I mean, DOL was even thinking about, instead of doing all penalties, would have the employers buy billboards and with the seatbelt message in Spanish in lieu of paying some of the penalties, just to get that message out to the workers, or running commercials on Spanish language TV on seatbelt usage. Doing something, thinking outside of the box to encourage, you know, seatbelt usage and the safe transportation of farm workers. So I'm almost done here. I have my 2 or 3 slides.
Okay.
Yeah, go ahead.
So how under MISPA, the person who's responsible is, if you use or cause the transportation to be used, then you're responsible. That's how they base it. And if your crew leader, supervisor transporting, you're automatically on the hook. Carpools exempt, immediate family exempt, farm machinery. I talked about these already. And these are all the requirements. Driver has to have the correct driver's license. Vehicle has to be inspected by a mechanic, CHP. It has to be operated safely by the driver. Adequate insurance, $100,000 per person per seat. Proper transportation registration, medical certificate. And if you've met all this, you can disclose the fees you're going to charge to the worker, but it could never be more than the cost of transporting that worker. So it'd be like the cost of a full tank of gas divided by 10 workers. That would be your share. So it costs $80 to fill up the tank, 10 workers, $8. So that would be your cost. Okay, and that's me. That's my email. If you guys want to contact me, impact.aglabor@gmail.com. But this topic, very dear to my heart. I think that in my 30 years with DOL, I saw minor improvement, and then it dropped again. And I think with workers having to travel long distances, they're going to rely on Raiteros to get them there for the extra $1 to $2 pay that they might be getting if they go a lot further away. So they're putting their lives in danger to trying to survive and support their families.
Thank you so much, Ruben, for your work on this and for helping people comply and raising awareness. I know my colleague, Member Broad, had another question.
Yeah, so Ruben, I spent like 40 years on this issue. It's not just farm workers, it's across transportation for hire, including truck drivers, bus drivers,
Construction.
everybody.
Yeah.
And the issue the problem is when it's regulated as a safety issue, in order to encourage people to engage in commerce legally, there are never enough commerce police. There are not enough CHP officers.
That's right.
You could triple the number of people and they couldn't make a dent in this problem. The problem, ultimately, in my experience, is that the Raiteros can't make enough money they don't earn enough money, even when they're overcharging people, to make the business capable of following the rules. They have to cheat in order to stay in business. And so the only way for the state to deal with this is ultimately, and it sounds like they already have a rate regulation rule, but it's really probably observed in the breach because there's nobody to make it happen. And, but I think that obviously it sounds like the legislation we did in the last go around was helpful in the category of 9 or more passengers driving traditional vans or buses that are regulated as commercial vehicles and always have been. And now what it is everything is falling into this gray area of unregulated.
Yep.
Right? You would agree with that?
Yes. Mhm.
Okay, so obviously attention needs to be placed on that group, and the cruel reality of it, in my experience, is you have to drive the number of operators in the group down to the point where the remaining operators have enough business that they can sustain the service and make a profit and operate safely. In other words, you got to drive 75% of the Raiteros out of business permanently. That's the only real solution, so that there are capitalized companies. This is an expensive little business to run.
Yep.
Because you have a vehicle, you have to keep it in operating condition. You have to have a driver who's not going to fall asleep, even when they're driving in the middle of the night. You have to have a driver subject to hours of service regulations that are observed. They have to have the vehicle inspected. They can't be driving on bald tires. They can't be driving old, broken down vehicles. They can't go anywhere where people aren't wearing seatbelts. The seatbelts need to be of a design that actually will save people's lives. It's a big regulatory cost, but because it's farm work, it's ignored largely. There's just no people there to enforce it. Anyway, I'm going to continue this conversation with you because I think there needs to be a discussion about what kind of legislation needs to be done that can successfully impact this, so that there's enough enforcement and that it makes a significant change, because this is unacceptable.
Yeah. Agreed. Perhaps, I think the big deal right now with FLCs is that, like you said, there's a ton of FLCs out there. It doesn't take much. You take the 9-hour class, pass the test, pay your bond, do all of that. But I teach a 9-hour class, and every time I teach that class, everyone that's been in business for 20 years, raise up your hand. There'll be 5, 6 hands. And anyone over 10 years, raise up your hand. It'll be a couple of 2. And then I would narrow it down. Okay, how many, your first year, you've been operating maybe 2 years. A quarter of the room to a third of the room will raise up their hand. Lots of people going into the industry. I'm just wondering how many of them are going. And so a lot of the FLCs that are willing to drop their rate so low that the ones that are are in compliance, and it's difficult to compete with them. They're the ones that are
Right.
more likely to have the safe bands, to have them inspected, to have, be willing to pay for all those expenses. They're competing with these folks that are, I don't know, that are just lowering. And the thing is that some of the growers are enabling them to exist by hiring them because they have such a low rate. So I think that 75% reduction maybe be necessary for the FLC industry because the FLCs that like I mentioned, the H2A FLCs are not all of them are big, but a lot of them have invested money in buses and vans and have charged their growers for that cost. And so there is some success in that they're charging for that cost and recouping that money. I'm not sure if that's going to work for non-H2A unless it's a requirement. And perhaps a requirement, hey, if it takes workers, if the majority of the workers takes them more than an hour and a half to get to work, normal commuting, then perhaps an additional percentage commission should be added to that their rate, because that'll at least enable them to ensure the safe transportation, right? You're expected to pay your FLC more when it's further, and that FLC is expected to provide transportation, just like the Valley Garlic and Fisher Ranch. They had to do that. Most of their workers come from 2 hours away to an hour and a half to 2 hours away, and it worked. And the FLCs wanted to charge at first $5, and maybe they had a handful that took it. But once they offered free transportation to the workers, they all signed up for it. The FLCs would pick them up at a parking lot in different cities, pick them up and drive them to West Fresno County, to Hollister, and they were happy. No accidents, no issues. Those 3 or 4 years that they did that, not a single issue happened in those years. I'm not sure if Valley Garlic is still that, and if those FLCs that operated the free transportation are still doing so. I probably should go circle around and check if they are, but it'd be interesting to find out if they are, especially if Valley Garlic is still paying for that. That'd be super interesting, because maybe they do have that contract that they have that they would pay for transportation, that template. So maybe we'll have a success story there.
Can I just ask, go ahead, Ram.
No, I was just gonna say, if those court orders resulted in a successful model, that would be good to know about.
Yeah, exactly.
Ruben, I saw in your material some allusion to somebody choosing to be covered by workers' compensation insurance. And when are these farm workers, what are the circumstances in which they're covered by workers' comp during the ride? I assume it's when they're being paid wages for that
correct.
period.
Yeah, you would think now on H2, I think all the carriers know now that transportation is a requirement. So now the workers' comp are offering 24/7 coverage for housing and transportation. But for transportation, there's very few companies that are going to provide the coverage for transportation unless the FLC discloses upfront to the carrier, I'm going to transport workers. Then their rate will be adjusted for that risk factor, right? They're going to be transporting workers. What a lot of FLCs do is they don't disclose to their workers' comp that they will be transporting, so they can get that lower rate. An accident happens and coverage is unknown at that point. But yeah, I mean, so the Migrant and Seasonal Agricultural Worker Protection Act, it's either $100,000 per seat coverage, a bond, which you can do what hardly no one uses, and then workers' comp. Then you need a property damage along with the workers' comp. But when DOL would conduct investigations, we always determined we would call the carrier and determine if the employer reflected on their application if they were going to transport or not. That way we can determine if there was going to be coverage. Sometimes they would battle it out in the courts with the under the workers' comp laws, and sometimes the workers' comp would cover that transportation. I think it's called coming and going rule.
Yeah.
And they would fight it out, and sometimes they would be covered. I think other times they wouldn't be covered. But for DOL to give authorizations, they wanted 100% assurance that the policy was written for that coverage, not that it's going to be debated in court a year later and determined then. But yeah, workers' comp, but the FLC or the grower has to relate that they would be transporting legitimately if they wanted to be covered by workers' comp.
Thank you.
All right. Do any of my other colleagues have any questions or comments? I will open it up now to other attendees of the meeting, members of the public, some of our own staff who may have questions about the presentation. If you wish to ask a comment, please use the raise hand feature in the Zoom application, and then Santiago or Satya will facilitate you being able to ask a question. This will also be our public comment portion of the meeting. So Santiago and Satya, do we have anyone that wishes to ask Ruben a question or make public comment?
No one's in the queue or indicated that they wish to make comments. At this time, we'll ask our attendees to raise their hand in Zoom if they wish to ask a question or make a public comment.
And Santiago, I just realized you had a message that I was talking too fast.
No, you're good. You're good. Thank you. I don't think you were. It was just more of an advisory.
Okay. Very well.
Okay, not
Okay.
seeing or hearing anyone wishing to make comment. We will thank you, Ruben, so much
Thank
for this
you.
presentation
Thanks
and
for
again
having
for
me
your
here.
work. Good to see you. Good
Likewise.
luck. Please let us know if there's anything we can do. Take
All right.
care.
Thank you so much. Okay, bye.
All right. And with that, the board will now recess into closed session. Thank you.
And thank you, interpreter. You are free to leave the meeting once you've concluded your comments.